Hello, everyone. Welcome back to Wills, Trust, and More. And, of course, we have Eileen, Kerlin, Walsh.
Thank you, Ron.
Thank you for coming back and sharing with the viewers another very interesting topic. And we're going to be talking about estate planning. Estate planning, 2 words. It means a whole lot more. If you want things done the way you want to see them done, if you're incapacitated or you have left and passed on, you have to have a trust. You have to have a will. You have to have some kind of a plan. There has to be an estate plan. There's all these things that need to be put in place. But I understand you're going to share some things with us that well-known celebrities.
Absolutely.
Interesting information. I'm not going to say anymore. I'm going to let you tell us what they did.
Yes, estate planning for the rich and famous. You would think because they have access to one, they have a lot of money, access to the best advisors that there is out there, that they would do it very well, that they would do it adequately and on time. And as we will see, that is not always the case. So I think it would be it's good for us to take a look at these estate plans of the rich and famous because they're in the public eye. They are household names. They get people's attention. So if we take a look at what they have done and what they have not done, it'll help us to see the importance of getting our plans in place. Maybe a little more humble than what they have, maybe a little less in the public eye, but every bit is important.
Okay, but don't you think because they're a celebrity is very wealthy, they have a lot of advisors, but they're so busy, they don't take time out for the important things for their own, planning, right?
And that's probably a good point, Ron. It's probably their lives are so busy and so scheduled and they're constantly moving from one place to another, they don't have time for this planning. It's probably also many of the things, even as we look at these plans, we see celebrities are no different from us. They're very much like us. And they probably too, maybe even a little bit more, feel invincible. They feel that they can always put off estate planning because the end is never going to come or the accident is never going to happen. And what we know is these things do happen. We don't plan them. We don't want them to happen. We do our planning and hope they're way, way in the future. But the bad things happen. The unexpected things happen. And getting the estate planning in place is as important for someone with a small estate plan, a huge estate plan, for the unknown and the rich and famous.
But also, they may do a draft, but the draft may never be completed. It may be inaccurate, it may be outdated in some way, am I right?
Absolutely. Often when a celebrity dies and we get to see that there isn't a plan in place or not a good plan, the first thing we look to is blame the lawyers. But often the case is these people may have started planning and not finished it, or they may have been recommended to take a certain course and decided that that was not where they wanted to go, or they just didn't make the time to get it done. So again, the illustration is they're just like us. They either start and don't finish, they start and plan inadequately, or they don't do anything at all.
And you have the situation where the trust is unfunded. And you have just a myriad of things. I'm going to let you just roll with that whole situation.
The first thing we'll take a look at, Ron, is who did no estate plan at all. And that you would think is just unthinkable because so many of us, with our busy lives and with our modest estates, get it done. And of course, because I'm in the field, I'm more advocate for that more than most. But Abraham Lincoln, not only was he the first president assassinated, he was the first president to die without a will, and he a lawyer himself.
Not even a will.
Not even a will in place. So that was very, very surprising. Yes, he died unexpectedly. It wasn't after a long illness, but still for a president and a lawyer not to have a will, very, very surprising. Pablo Picasso, famous artist, massive estate, and famously frugal. It was said that when he would write a check to someone, in addition to signing his name, he would put a little sketch on there with the hope that they would find that valuable, keep it and not cash it.
Oh.
So he had a massive estate and no will, which cost, I think, 30 million additional to get it settled to his heirs. Musicians, Jimi Hendrix, Bob Marley. Yes, Jimi Hendrix died suddenly, but Bob Marley died after a long illness. No wills. many claims against the estate. These musicians also, not only do they tend to have valuable estates at their death, but their estates grow. Even the death gives people a renewed interest. So these estates grow. They become more and more valuable after death. And to not have anything in place to take care of that, extremely costly. The only person benefiting from that is the system. And finally, Sonny Bono, a musician, a politician. Again, he died in a skiing accident, but he had a complicated life and a large fortune and no estate plan. He left a wife at the time of his death. He left his ex-wife and ex-partner, Cher, a child, and even a love child who surfaced after his death, all to be taken care of and all fighting over his estate. And when these celebrities die, these battles get epic. They're big, there's so much money, they're fueled by public attention. And even that gets attention to those involved who are in the public eye. So just very expensive legal battles that happen, that don't have to happen because of no wills at all.
And you have people coming out of the woodwork claiming that they are they are contesting because of the size of the estate.
Absolutely.
Yeah, they figure they're going to get a small portion, which is going to be millions.
Such as these children
Yeah.
coming forward saying that they're the child with the descendant.
Yeah.
All of that can be planned for in advance. And you mentioned trusts. You know, there are some who do just wills when they really, really would have needed a trust. Warren Burger, for example, the Chief Justice of the United States Supreme Court, died with this tiny little will. He wrote it himself. He said who he wanted the estate to go to, who the executors would be, and indeed he had it witnessed, so it was a valid will, but no powers for the executors. So when we do a will, we indicate in there all the powers that the executors have. Because he gave his executors no powers, they did not have what they needed to sell his real estate, pay his taxes. So therefore that cost a large portion of his estate. So while he had a will, he didn't have adequate powers in there. Heath Ledger, whom our younger viewers will know as the Dark Knight, a young, brilliant actor, died young, drug abuse, as many of these are. He died with a very old will. So he got a will in place, but he never updated it. So he had left his estate to his parents and siblings, meanwhile had a child that he acknowledged. It wasn't as if there was any contest over the paternity, but had never updated his will to include the child. So your child is not automatically entitled to your estate when you have a will. So the child and the child's mother was set to go to battle with the original family. However, they did settle it, luckily, because even if you're wearing the white cap, even if you know that you're right, even if you think you're going to win, a legal battle costs a lot of money, takes a lot of time, and is emotionally very trying. These two parties luckily worked it out, settled with most of the estate going to the child. So they prevented all those years and all that money because the will had never been updated. So the lesson is, you know, not only do these plans, but get them updated also. Another very interesting will is Lady Diana. She had a will, she had some trust planning, but she left these very specific bequests to her godchildren, and she even said how much was to go to them. But she also included confusing language to give the executor absolute discretion when it came to the gifting. So the executors decided not to make the gifts. These godchildren didn't even know at the time that these gifts were mentioned in there, but that they never received, and as one of them sniffed, all they got was a few grubby trinkets. So I think it's fairly clear to us that she intended these gifts to be made, but she called it a grant of wishes rather than...
Oh.
And given this discretion to the executor, she ended up with probably her wishes not being fulfilled.
Yeah.
So not only do we want to get our legal intentions into these documents, we have to give them legal effect. We have to make absolutely certain.
The wording is exact with what you wish for.
And that it does reflect what we intend.
My notes show there was something about who is one of my, I like his acting, James Gandolfini.
James Gandolfini is a good example of someone who did some estate planning, but not enough. He relied heavily on a will. He did no tax planning. He also was a little confusing about who would get what. He mentioned out of country property, but ultimately he lost about a third. I think his was about a $30 million estate, and a full third of it went on taxes because he relied on a will and didn't do adequate trusting with all the tax savings language that we can get in there. So unfortunately, a large portion of his estate did go to taxes that could have been avoided. Another actor who died unexpectedly that we all really liked was Philip Seymour Hoffman.
Yes.
Now he, by choice, not by accident, decided not to do any children's trust. Now he had young children, but he was an interesting man, and he said he didn't want these spoiled brats, he didn't want trust fund babies, so he left his money to his partner, not his wife, but certainly the mother of the children, to make the best decisions for them. Had he talked to me, I would have said, we can do so much more with these trusts, because he indicated as well that he wanted them to be cultured, he wanted them to travel, he wanted them to be exposed to the world, not to be narrow. He could have done all that through trust funds for them, indicating at what age they would get their money, indicating that they would maybe only get certain portions if they had reached certain goals. By giving all the money to his partner to make that decision for them, he ultimately had no decision over it. So certainly children's trusts would have been very, very beneficial for him. Another really interesting trust or estate plan is Michael Jackson. We often talk about funding trusts, Ron. We always say not only get your trust done, but get it funded. Michael Jackson had a will, had a trust, but didn't do his funding. So he had these beautiful documents sitting in a beautiful binder that we speak about often, but nothing in them. So he would have intended, certainly Michael Jackson more than most would have wanted his intentions to be out of the public eye, but because he didn't fund his trusts, these assets were sitting in his name. And even though they would go pair the trust, they had to go through the legal process. So a probate is opened, everything is the public eye.
Public, yes,
we get
and
to learn,
text.
Exactly, and we get to learn about his mother's $1,000 a month grooming habits,
Yes,
given this
all this personal stuff.
all this personal
Surfaces.
stuff we shouldn't know, but we as the public do eat up. And for those getting this, for all of us, if we don't want this to happen, get a will, get a trust, get it funded, and make sure you keep it up to date. It's that simple. Another really interesting estate plan that had a trust but not adequate was Leona Helmsley. She was that hotel magnate who famously said taxes are for the little people, and left $12 million to her dog Trouble. Well, as we have talked about before in this show, Ron, you can set up a pet trust if a pet is the object of your affection, and you can do it right so that no one can challenge that. Leona Helmsley left money to some grandchildren, but not to others. And she left this $12 million to her dog. The grandchildren that she had left out, now she never specifically said I don't include them, which we like to do just to make sure there is no question. They challenged her capacity at the time she did the estate planning, said the fact that she had left all this money to a dog meant that she wasn't in full capacity, and their challenge was successful, and they got $10 million of that 12.
Oh my gosh.
Now many might say the dog didn't even need $2 million, but really what it's about is someone's intention. And if
Yes.
somebody has money and has an estate, it's their business who they give it to. Those grandchildren did not deserve that money if she felt that she didn't want to give it to them. So it's another little cautionary tale. Get your trust done, and if you have an intention, make sure your trust is solid enough to be able to reflect that legal intention.
Now, if you have a pet trust and the trust outlives the pet,
you decide
what happens as an alternative?
Well, you would, within the pet trust, you would say what happens when
Okay,
that.
it's all built in.
Yes, it's all built in, and many of our clients will then have it go to PAWS or go to a shelter. They'll often have it go to a charity, because if they're already naming this pet, maybe that's really where all their intention and wishes lies. But as we've said before also, sometimes a pet trust is just part of an estate plan, and the money is going to other family members also. And if that's the case, then maybe that residual language will say then that's where it goes. But it's all built in. That's absolutely the answer.
Boy, you covered a whole lot of stuff. I'm going to let you conclude.
Okay, I'll be happy to just keep on talking because there's another really interesting
Okay,
estate
go
plan.
ahead. I'm cutting you short. I didn't
No.
mean to.
Casey Kasem.
Yes.
So beloved.
Yes.
Scooby-Doo and all those years of
Yeah.
the top 40. A very ugly situation occurred because he did not update his lifetime documents. As we know too, estate planning is not just for after death, it's for during life. And he had a power of attorney for healthcare that named his daughter, even though he was married to a woman who was not that girl's mother. So he did develop dementia. And then we had this bizarre situation where the daughter had authority over his healthcare and even over where he would be placed. She was at war with the most recent wife and they disagreed. So we had this ugly, unseemly situation where this beloved icon was just being moved from state to state, facility to facility, based on what judge ruled in that particular case.
Area, yeah.
And he has recently died, and those two are still at war. But a good estate plan, now a good power of attorney for healthcare, maybe that was his intention. We don't know when it was drafted. Maybe he did want his daughter to have that authority, but if it was an old power of attorney from prior to his new marriage, then that was an unfortunate update that was overlooked. So it really was so sad to see what happened to him both before his death and after, because his family and the new wife couldn't agree. And as we know, Ron, so often these are the wars with the blended families, the children from previous marriages. So when those things are in place, we really need to do some adequate planning. And that brings me right to my next point, and that is, who did it right? Frank Sinatra had just that very situation. He had a new wife and adult children from previous relationships. He drafted his estate plan solid, Fort Knox. His children were not happy with the portion of estate that went to his new wife, and there wasn't a single thing they could do about it. No legal battle, no loss of the estate.
But that's what he wanted.
That's what he wanted. He did it right. So it's possible to do it right. Another example of getting it right is Joan Rivers. Very recently death, again, a little controversial, but very, very well known. She had it locked up. She was a smart woman. She had had a trust for many, many years. She had 11 amendments to that trust and 3 restatements. That indicates maybe that she changed her mind a lot, but ultimately she looked at that trust a lot. She didn't just get it done, put it away, and then it was never looked at again for another 20 years. So she kept it updated. It's said that her estate went to her child, her grandchild, and her friends, which is what she wanted, but we don't really know because it's out of the public eye, because it was all done properly through these lock-solid trusts. Now, if you go to the state of New York, you will find that a probate has been opened in her name. And why? Not because anyone is contesting or that she didn't do her documents properly, but because there is a wrongful death action. So when we have a wrongful death action,
that changes it a little.
Well, in order for someone to be appointed to represent the estate, it has to be legal. It can't be the trustee of a trust. Even if you give someone that power in a trust, it's not good enough. You need that representative appointed by a court to represent the estate for the wrongful death. So that's the only reason her probate has been opened.
No, has that been settled?
Oh gosh, no, that's just getting started.
That's what I thought.
Yeah, as we know, these wrongful death lawsuits take a very, very long time. But that's why her probate estate is opened. None of her estate matters other than the wrongful death is in place. And we'll just conclude with someone else who did it very well, and that's Thomas Jefferson. Not only did he draft famously the Declaration of Independence, but he did a really good will. He had testamentary trusts in there. He took care of his wife. He took care of his daughter. His wife had predeceased him. He took care of his daughter, indicating also that because her husband was having financial troubles, he really took very good care to make sure that his money only went to his daughter, was never going to be subject to her creditors. And finally, he bequeathed his slaves their freedom, which is a nice indication of the place and time that it was, that was his intention. It just really indicates that
what a super guy
in civil liberties that our country was going through at that time. So in closing, what did we learn from the celebrities that we like to look at, whether we admit it or not? Get an estate plan done, get powers of attorney, get lifetime planning, get a will. If you need a trust, get it done, get tax planning done, make your intentions well known, get this all in somewhere, keep it safe, and keep it updated. make sure that if some big life change, like Heath Ledger's daughter, births, deaths, marriages, divorces, big massive life-changing events often trigger changes in the estate plan. So get it all done, get it all done correctly, and keep it updated.
And to do that, you really need guidance.
You really need guidance. You hopefully will get expert guidance. You'll get guidance with someone experienced in that area of the law. Warren Berger, writing his own will, he didn't do estate planning even though he was a lawyer. So, and as I say, as we said earlier, if you represent yourself, you have a fool for a client. So you want to get to someone who does this well, does it all the time. We all know what we do every day. We become very familiar with and hopefully very good at. So get help, get expert help, and get it done.
Well, for those people that do not have contacts to help them and guide them, we're going to put your number at the bottom of the screen.
Lovely.
And I'm sure you're going to be getting some phone numbers, some phone calls rather, and you can guide them accordingly and go from there.
Absolutely. Happy to help.
Good. Eileen, thank you again for coming out and sharing this with us. And thank you for being part of the Channel 4 team and doing a lot of the shows that you do. It's nothing but good reviews coming back, and just want to thank you on the air for what you've done. And you have a practice, and you're so busy, but you still find time for Channel 4. We appreciate that. I want you to know that. You have a good holiday, and to the viewers as well, Happy New Year. Have a safe New Year. Merry Christmas to everybody. Merry Christmas to you again.
And you too. Thank you so much, Ron, and I'm delighted to be here and be part of Channel 4.
Good. Thank you. See you next time.